proclamation.
Stand. Father, I want to thank you for this day you blessed us with. Another day to do the work that the people expects of us. Father, for those in our community that are hurting this morning, I pray that, or this afternoon, I pray that you'd touch them, comfort them as only you can. Pray for Curtis. Pray that he wasn't injured very bad a while ago. Pray for our nation. Pray for our leaders. Pray for those folks next door who have the difficult task of getting to the bottom of what we've just done. Father, go with us now. Be with this committee. Be with the chairman. Be with those in our audience, and give us safe traveling grace as we leave here this evening. In Jesus' name I pray. Amen.
Amen.
Meredith Brady.
Here.
Bill Anglin.
Here.
Bill John Baker. Jack Baker.
Here.
Harvey Buzzard.
Here.
Julia Coates. Brad Todd. Joe Crittenden.
Here.
Jody Fishinghawk. Here. Janelle Fulbright.
Here.
Don Garvin. Chuck Hoskin Jr. Tyler Gloria Jordan.
Present.
Curtis Snell. Chris Stolt. David Thornton. Cherokee Watts.
Honey. We do have a quorum. Mr. Crittenden, can you give us an update on Mr. Snell, Curtis Snell? Curtis was involved in a traffic accident, but you have the latest, right?
Well, we went down, we heard, I was down the street and I saw some marshals turn around and go down. We got a phone call, and so I went to see how bad it was, and he was down by Walmart, and he was turning left on the bypass like he was going to go on to Holbert, and somebody rear-ended him. They had him in the ambulance when we got there, so I didn't get to talk to him. But he didn't want to go, but they wanted to check him out, afraid he might have whiplash or something. So we went on to Hastings, and they brought him in and rolled him in and took him in for examination. And I think he's hopefully not hurt very bad, but he did have an accident, so I just wanted to tell you.
Good news, thank you. Next order of business, approval of the May 26th regular session minutes.
So moved. Second.
Moved in second, any discussion on the minutes as written? All in favor, signify by saying aye.
Aye.
All opposed, same sign. Minutes stand approved as written. Next on the agenda are reports. Ms. Wright, from the Marshal Service.
You have my report. I submitted the written report, and on that I'd just like to expound on the grand larceny that was down in the Adair County area. There were several thefts that were occurring, and we had a marshal that was working in that area and got some intelligence. So several families were affected on Arkansas side and the Adair County side, and he was able to get a warrant based on some information he got. So that one was a pretty big thing, and he'd worked with Adair County on that. They tried to go federal, but there weren't firearms involved, just a lot of jewelry and other items, so they couldn't get it federal. But he worked with Adair County and maybe Stillwell on that case, so it was a pretty good thing. Other than that, on the other items that we worked on, we did the summer youth camps. We had both marshals and security at each of those camps, and we also had marshals and security at the clothing vouchers, because last year we had some issues, so we've been involved with all of those this year too. Any questions?
Questions? Ms. Fishinghawk?
Was you all involved in that cherry tree aid over there?
The what?
The cherry tree aid over there
Where the assault was?
with the fest banana. I don't know about.
Well, we did call the feds in on that because we were afraid that the individual that
I'm
would
talking
have met
about when we had
that
about 8,000 pages of documents, texts, all that.
level. Oh, no,
Oh,
No.
okay.
no. I thought you were talking about the assault. We did call feds in on that, but it didn't end up as bad as it appeared it was.
Well, no, I was curious. I was just, the reason I was asking, I was curious how you handle it down there since it is cherry tree in our addition. I was just wondering how it was handled.
Yeah, and I'll have to look at, I'll have to ask, because I don't know of that. I have no idea, but so I'll have to ask.
Thank you.
Ms. Corey Jordan.
Sharon, back when we had to have the inventory review, I believe it was by an independent person that we hired or company that we hired. Is that correct?
Well, it was in two parts, so I'll have to get that straight. The first part was the evidence inventory, and that was BIA. And we had company come in and look at the administration part of that. Gave-
Procedures? Okay.
And then on the second part, that was supply, and that was due to the Mark Cummings case where he had stolen some supply. And that I actually did do a contract with an outside person to come in and assess us. And that was done separately than the other.
What was the cost and how did we pay for that?
It was through a contract. I did it through on, I believe, DOI.
And was there a reason that we did it through DOI versus maybe just doing it through your budget?
DOI had some monies that were allocated to us late last year that we incorporated this year that wasn't tagged for anything. And our motor fuels budget, which is my operational budget, the monies were pretty much being utilized the way that we thought it would be, and we're right at budget on that. I mean, we don't really have much leeway on it.
Okay, and do we know what DOIs, where this money that we allocated to pay this contract, do we know where that money came from? What pot of money it came from?
The DOI money? Yeah, they gave us a one-time, they gave us 3 pots of money, DOI did. They gave us some specifically for the evidence and the upgrade of the system and some cars. They gave us money as an increase to our base, and then they gave us a one-time allocation based on, I'm not sure, some calculation they did to all the tribes, and we got a one-time, this is your money. In the law enforcement item for all law enforcement across, they did some computation and all tribes got that one-time funding.
So all of what we did here as far as reviewing our inventory and procedures was paid for with federal funds? Thank you.
Any other questions, comments? Sharon, I have an email I received from the Assistant Police Chief in Pryor, Derek Melton. He asked if I could contact the Chief Law Enforcement Officer for the Cherokee Nation and let them know that he and Chief Nichols at Pryor Police want to congratulate Officer John Ketcher for his heroic actions on June the 16th when he saved the life of an armed and barricaded man. John was very brave and professional and could have saved the lives of our officers. And he said, I believe he deserves honorable mention. So if you don't mind passing that on.
I will, and we usually do our awards toward the fall, and I'll make sure, if I get a copy of it, I'll make sure that that gets in for that. But I will let him know. Thank you.
I'll just hand this to you when we're finished.
Okay.
Thanks. Any other questions or comments? Thanks, Sharon. Ms. Hammonds, Office of the Attorney General.
Thank you, Madam Speaker. Good afternoon, Council. I would like to reserve a little of my time, if I may, for Susan Work. I think most of you know Susan. She's one of our senior assistant attorneys general, and last week she was in D.C. for the Cobell Fairness hearing. I could try to give you a brief update on that, but it would be much more effective and accurate if it came from her. Briefly, before we do that, I wanted to, I had some questions last time about our outside counsel budget, and I have some of those figures. It'd probably be best if I follow this up with a written report, because these have my notes on them. But we have the advocacy budget, which was budgeted at $500,000 for the fiscal year. I think we used to call it Constitutional Defense Fund. That's primarily for issues surrounding the Friedman case and legislative defense and all of those things connected with it in Washington. We are 17% spent in the fiscal year on that. That's down considerably from prior years. I think the total encumbered, and this is as of the end of May, is $85,000, $85,655 out of 500. The other big budget is what we call the litigation budget. It was budgeted at $313,046 for the year. That includes everything else, basically trademark defense, various actions with the United Katua Band, such as the land into trust issue. We paid a big portion of the COSI arbitration, the COSI matter that you all will recall. So big ticket items, Arkansas Riverbed, the dispute with HUD over UKB financing, and then, more run-of-the-mill, bread and butter type legal issues such as the California probate, those things. And the total of that, out of the $313,000, we have spent 35% of that as of the end of May, for a total dollar amount, it looks like a $45,322 that we've actually spent. Now, more than that's encumbered because and undoubtedly I'm going to say this wrong because I'm not a numbers person, but I understand that if you enter a contract for $200,000, even if you don't spend all of that $200,000 for the year, that shows up as an encumbrance in our accounting because you've encumbered that amount to pay it. So we've encumbered more than that, but we've actually spent $45,322. So I guess the good news is outside attorney fees are down considerably from prior years. Of course, we have no way of knowing if that's what it's going to be like next year. With that, if there are any questions for me, I'll take them, and I'll let Susan tell us about Cobell.
Any questions for Ms. Hammonds? Susan, would you mind coming forward? Thank you. Thanks for being here.
Thank you. Good afternoon. You all have probably heard a lot about the Cobell case, and the parties entered into a proposed settlement agreement late last year, and Congress approved it and appropriated several $billions to fund it. When Congress approved it, it included some conditions in the legislation that weren't in the original settlement agreement, and the parties amended the settlement agreement slightly to conform with that. The judge approved the settlement tentatively earlier this year, but subject to a fairness hearing, which is the hearing that I attended last week. And the purpose of the fairness hearing was to enable class members to file written objections and request to appear at the hearing and advise the judge as to what objections they might have to the settlement. And there were only about 90 objectors to the settlement, and only about 19 requested to appear at the hearing. And our office assisted an individual Cherokee restricted landowner in preparing a written objection to the settlement. Well, not so much an objection to the settlement itself, but an objection to a couple of terms of the settlement. And I'm going to explain that a little bit more in just a minute. Probably about, I think maybe a dozen or so people actually appeared and testified to the court last week, and many of the objections were objections to the amount of the attorney's fees that the plaintiff's attorneys the attorneys were requesting. They were requesting about $222 million as their fees, and the settlement legislation allowed the judge to award them between $50 and $99 million with an understanding and an agreement that the federal government would not appeal if they got an amount within that range. But they asked for almost twice that amount, or more than twice that amount. The hearing lasted pretty much all day. The attorneys each presented their statements to the court as to why they thought the settlement should be approved, and both sides wanted the settlement approved, which is significant. The objectors each got about 10 minutes to testify, some took longer than that. And then after that, the attorneys responded to the objections, and then the court recessed for 10 minutes and came back and approved the settlement. And from the statements the court made that were fairly detailed, you know, it was pretty obvious that he had already had his decision outlined ahead of time, approving the settlement. He did acknowledge that he appreciated that the objectors came to the hearing, and said that he took that into consideration, but his ruling didn't really reflect that. So the basic terms of the settlement are $1.412 billion to be distributed to the Accounting Trust Administration Fund, plus $100 million for an adjustment fund that would be used to actually increase some of the distributions to the individual class members. And out of that, the judge approved the $99 million to the plaintiff's attorneys for their attorney fee award, and a $3 million award specifically just to the plaintiff, Ms. Cobell. The parties argued that she was entitled to that because of all the time that she had spent over the last more than 10 years on the case, and the judge agreed that she should be entitled to that award. Another portion of the settlement is $1.9 billion for a trust land consolidation fund, and that is to be used to purchase fractionated individual Indian trust lands. And out of that fund, there's also up to $60 million to be used for an Indian Education Scholarship Fund for college and vocational schools. Our concerns about the settlement are that there's two classes. One's a historical accounting class, and that class consists of anyone that had an IIM account as of September 30th, 2009. So that class is easy to identify, and those class members will each get $1,000 as part of the settlement. The other class is more difficult to determine, particularly in terms of Cherokee citizens, and that's the trust administration class. Anyone that has an IIM account as of September 30, 2009 also gets to participate in the award under that class, and that amount is a baseline payment of $500 and an additional pro rata share, so that the total estimated payment is $800 for those class members. So if someone has an IIM account, they're going to get the $1,000 as part of the historical accounting claim, plus they'll probably get an extra $800 as part of the trust administration claim. The problem with the Cherokee Nation restricted landowners, and also Choctaw and Muskogee Creek landowners, is that they are not part of an identifiable system of federal records to identify their restricted land interest. And the Department of Interior is supposed to work with a trust administrator to identify trust administration class members that don't have IIM accounts. And the federal government has said they're going to rely on the TAM system, which is a federal system of records identifying restricted property interests. But because the Cherokee Nation and the Creek and Choctaw Nation are not part of that system, there's a problem identifying the individual restricted landowners. And we brought that to the attention of the court. We previously brought that to the attention of the plaintiff's attorneys, and unfortunately nothing was done to address that. The plaintiff's attorney told the judge, after I had discussed this issue, that they were in the process of identifying restricted individuals from the Cherokee Nation, and the federal attorney said that anyone that thought they had a restricted interest could file a claim and could be identified that way. So the problem, an additional problem, is that there's a 45-day deadline for individuals to file claims, and it starts to run from the date of the final approval. The date of the final approval under the agreement is after all the appeal times have run and any appeals have been litigated and resolved. So it shouldn't be a deadline that's coming up really, really soon, but it's coming up soon enough that it's going to be important to get more notice out to individuals that might own restricted land and that aren't in the IIM account, have IIM accounts. And so that's basically where we were at with that. Does anyone have any questions?
Questions? Yes, Ms. Conlon?
Susan, would you be so kind as to summarize that for us and send it to us so that as we get questions, we can review back on what you've told us and maybe be able to answer our constituents' questions? I appreciate it.
Mr. Buzzer?
So, Susan, if a person is an owner of restricted land now, should we go ahead and file?
If you don't have an IIM account, then it's a good idea to go to the Cobell website and get a form. For people that don't have access to computers, the Realty office has made forms available to at least 300 people already that have come in and asked about it. And I think that's the solution, is to just file a claim if you
File
think.
it anyway. The other question I have is, how many Cherokee citizens are involved? Do you know approximately how many they are? And then do you have any numbers, any dollar numbers that we may be receiving in eastern Oklahoma for the eastern Oklahoma part of the Cherokees? And any dollar figures or the amount of the total number of people involved?
You mean like total dollar figures or
Well,
just
total
per
dollar,
person?
But what I'm wondering, is there very many Cherokees that's going to be able to get in on the Cobell lawsuit?
Well, it's going to be difficult because they're not part of the TAM system, but the Department of Interior sent a notice to the nation, and I think it was June 11th, that they're providing $2.6 million in funding to assist in the research that's necessary. And Linda Donaldson's her office has already been working on that, and they started out with allotment records, and they've gone through and eliminated tracts of land that they know aren't restricted any longer. And when they get it narrowed down enough, they're going to contract with abstractors to go to each county record and research each tract to determine if it's still restricted, and then try to identify who the owners might be. So it's going to be a complicated process. So it's hard to estimate, but I think Linda told me that she thought that it's possible there could be as many as 4,000. I think she said tracts involved.
Okay, so those records will be the Cherokee Nation's records after this is done?
That's right.
Okay, well, that's great, because right now we have no way of tracking that land. I know Sharon, some of the marshals, they have problems sometimes in identifying whether it's Indian land, trust land, restricted land, or what, so, yeah, that's a good thing. And we don't have an idea of what the dollar amount could be.
Not a total dollar amount, no.
Okay.
But if it's an unprobated, if it's tract that it's a matter of heirs owning it, then they're going to divide the $500. Yeah, so it's not going to come to a lot of money, but.
Well, it's probably not worth filing for a lot of Cherokees over here, but, why not file? So, okay, thank you.
Mr. Baker?
She just answered my question, thank you.
Oh, okay. Any other questions? Thank you, Susan, for being here. Diane, was there any more for you on yours?
No, I don't have anything else unless...
Thank you. Is there anyone here from the Election Commission? Duh. Ms. Weston from the Tax Commission.
Afternoon.
Good afternoon.
I think you all have my report, and I will try to answer any questions that you might have.
Any questions for Ms. Weston? Good report.
No?
Thank you.
Thank you.
Ms. Hanby? Oh, you?
I'm not Miss Handy. I'm standing in for her. Good afternoon. My name's Angela Thompson, and I don't believe Vicki submitted a report. She's on travel right now for the 477 Child Care Conference, but she wanted me to update you on a couple of programs. The Child Care Program, on June 7th and 8th, the nation was requested as the first tribe to participate in the pilot project. The Department of Health and Human Service Office of Child Care is in the process of implementing a grantee internal control self-assessment instrument that could assist in reducing improper payments in the CCDF program, which is the child care program. There were 3 federal staff and 3 contractors participating in the pilot. Lori Hand and her staff should be commended for the program excellence and could be used as a model program for best practices. The other thing is the final payment of the 2011 allocations. OMB approved apportionments on June 3rd. IHS 2011 CR balance payments are in the process for all tribes. Other agencies are also in the process of paying those 2011 balances. And that's all. Any questions?
Any questions for Angela? Thank you very much. Thank you. Anyone from gaming? You're sure a lot better looking than Jamie.
Good afternoon. Jamie couldn't be here today. He had a family medical emergency, so I believe he submitted a report for June 1st. I can give you a brief update on that report. Our May compact fee payments totaled $1.3 million. Almost $1.1 million of that went to the state directly. Also, we made our June payment to the NIGC, and that totaled $130,000. Quick update on our gaming facilities. We had groundbreaking ceremonies both for the Ramona property and Fort Gibson. And set for this Friday, we'll be opening off-track betting facilities at our Salsa operation. If all goes well with that, we anticipate opening similar operations at West Salem Springs. So is there any questions?
Questions, comments?
Thank you.
Thank you.
I need her name.
She needs to record your name. I'm sorry, I didn't ask you.
I'm Tracy Asher. I'm the audit manager for the commission.
Todd's over at the election commission, so we'll move on down to Todd Inlaw.
Oh, not Todd Inlaw. He's asked me to fill in. I'm not sure if, he just sent me an email earlier today asking if I could come over and answer any questions. I don't know if he submitted a report or not, but if you have any questions, I'll try to answer the best I can.
Councilman Watts.
Thank you, Madam Speaker. If in the next report, a clear definitive answer about whether or not we're going to meet deadlines and obligations for the 2013 election, given where we're at, and expect to report on it and answer questions.
Okay.
Thank you.
I'll make sure he's here for that.
Yes, thank you.
Ms. Forsythe.
Yes, I talked to David Slaughter, he's head of our 911, and he would like to meet with you someday about the little pocket area around the Marble City that's not compliant yet, but he said they're almost there.
I actually met with him yesterday.
Oh, okay, good.
And discussed that very issue, so.
Okay, thank you.
Anything else?
That's all.
Anyone else? Do you know anything about the youth leadership?
I don't, sorry.
Oh, great. Hi.
Hi, I'm Kendall Horton, and I represent District 4 of the Youth Leadership Council. And I believe you guys have a report, if you have any questions about that.
Questions? Yes, Ms. Calmar.
I believe you're new? Is that, no?
I'm not. There's a new member from Tahlequah. He's Brian Barlow.
Okay, very good, thank you. And congratulations again on serving on the youth council.
Thank you.
Thank you. Okay, being finished with reports, we move on to old business. This is to discuss the policies and procedures, requirements for naming of buildings.
Madam Speaker, if I may, I talked to Councilor Hoskin, and he does intend to table this until the next Rules Committee, but he did ask that if I could ask Ms. Paula Rysdale to come up and just give us a brief assessment of where they feel like they're on the policy for this through administration.
So you want to make a motion to table?
I do. I'd make that motion.
Second.
All in favor of tabling after we heard the report, signify by saying aye. Aye. All opposed, same sign. Go ahead, Paul.
Thank you, Madam Chair. I do have a draft policy. I was hoping to visit with Mr. Hoskin. Be happy to share that with him when he's available.
Okay. Thank you very much. Oh, Ms. Fisher.
I have an act for her, for the Attorney General. I have a question for the Attorney General.
For the Attorney General? Want to come back?
Still here. I had a question because it was brought to my attention during all this mess. I know I'm looking at the laws right now for elections, Legislative Act 6-10. It says a voter shall mark his ballot in permanent ink.
It does.
Can you explain to me, because I've got this question and I'm telling them, hell, it's up in arms over here. If the law says to mark it in permanent ink, and it also says it has to be notarized, but then we got told that we didn't use, on the ballot, it not only said use number 2 pencil, then it went on further and says do not use ink. It went one step further, but our law says it should be ink. How do we decide to disregard this law but keep the one that says they have to be notarized? Selective is what I'm trying to figure out.
Okay. All I know is what I heard from the Election Commission at the hearing in the last few weeks that Ms. Free requested, where she posted a lot of questions from some members of this body and some other candidates for office, and that was one of the questions. The commission at that time said that AES, whatever it is, Election Services, thank you, the company that we use, use number 2 pencil because the readers, those machines, read the carbon-based number 2 pencil better. They will also read permanent ink. But it was a mistake. Now, what's the effect of that mistake? I can't tell you that. That will ultimately be something I believe that the Supreme Court will have to decide. It's my understanding, and I haven't double checked it, but I think our law used to say, as most or as lots of election laws say, either pencil or ink. And we specifically changed ours since the last election, and AES didn't catch it, didn't know. That was the explanation that I received.
Does anybody over here okay something before we let them send it out for us? I mean, does
The
anybody look at it?
the election commission handles all of that.
So it's up to the commissioner or the chairman to say this is okay?
I don't know logistically how they do it.
Who is our chairman up there? Is it Rohr or Johnson?
I think it's Mr. Johnson.
Do you know if he's had any experience in elections before?
I don't have any idea. As you know, the election commission is an autonomous body and they have their own council.
Well, they answered you, or they did on the old org chart. All the commissions I thought fell under attorney generals when I looked at the org chart. Or when we go through the budget?
At one point, all of those budgets flowed through Mr. Fight, and at one point through me. But the election commission and the Phoenix, I mean, they're autonomous. They're set up, appointed by the chief, presented by the semi-autonomous. And obviously, they're not freestanding. They're part of the Cherokee Nation. But they make those decisions, and we set it up that way. The Cherokee government, so that they would be outside political sway.
Well, I never think about it until a constituent brought it up to me, and I said, I don't know. I know we can't do anything that goes against our laws or the Constitution.
I've told you what I know. I think the short answer is it will ultimately be a decision for the Supreme Court.
Well, would you get back to me on, if you hear any more, you can research it, come up with more in your opinion. Could you get back with me on it, please? If you come up with anything else you ain't thought of?
I will certainly keep you apprised.
Okay.
Ms. Fishinghawk?
Finished.
Okay, thank you, Diane. Okay, under new business, we have a resolution confirming the renomination of Deacon Turner as a board member.
Move to approve.
I'll second.
Okay, any discussion on Mr. Turner? All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carries. Item 2 is an act requiring the establishment of a pesticide application notification system act. Ms. Callan Watts?
Move for approval.
Second.
Moved in second. Any discussion? By acclamation?
Yes.
All in favor, signify by saying aye.
Aye.
All opposed, same sign. Motion carries. Hey, any announcements? Gail handed me one. The inauguration for the new council, or for the council, is, next term is August the 14th, which is a Sunday. And I guess according to the Constitution, that's always August the 14th. Monday and Tuesday, August 15 and 16, are meeting days for August. Would you like to move the meetings to the next week, to the 12th and the 23rd? And let them use the week of inauguration as an orientation time? Do I have?
Let me just make sure I understood.
Okay.
So, the speaker's suggestion, so that there can be a proper orientation for the new council members, is to move those to the 22nd and the 23rd of August. I'll move to approve that.
Second. Okay. Moved and second, any discussion? So we move the August tribal council and committee meetings to the following week.
22nd, 23rd.
What is it, Tara?
22nd and 23rd of August.
Now, the week of orientation, we'll also need to have a special rules meeting to name and vote on chairs of the committees. Do I have Carrie, you got your calendar? Is there a date that anybody has a conflict on that particular date?
What day are we talking about?
So the week of orientation?
It would be improper probably to do it on that Sunday and get it over with while we're here. Can we wait till the following week? Or there's not, because we would have to have those people in place? I guess Monday afternoon? Or was that problematic for folks?
We were gonna use the first of the week to orientate them, to kind of let them know what they do. Todd was gonna go over Robert's Rules of Order and explain stuff, and then we thought maybe Thursday.
Would be a
Because I have to have a whole day for this, their payroll, benefits, any new ones I have. I have to have all those people come over.
What about, would Friday at 10 a.m. work?
That's up to you guys.
It's
Because
Friday.
I just need the new ones, the ones that are back in here already. I just need maybe a day and a half for the new ones to orientate them.
I'm gonna make,
Jack, can you be here by that time?
Yes.
Friday, what's that date?
I'm sorry,
What's the
what?
date on that Friday?
Friday, August 19th at 10 a.m.?
Yes.
Anybody have any objections to that? Or special rules?
Or I can even 10:30 if that,
Jack?
or
I was just
11.
gonna ask, what was the problem with having like 1 o'clock that Monday?
I guess it had to.
If we have our regular committee times, we can,
I don't know, I can't.
on the day of the
We're not
council
doing
committee
regular.
meetings.
We just moved them.
You mean the new
Okay.
meeting time?
Right,
Well, we need to have our committee chairs in place.
before, okay.
Mm-hmm.
Can we do that
Kara?
morning?
Except, the agenda has to be set 10 days prior, so it's already gonna be the old original, assuming they're changed or not changed. It would already be set. So,
Agenda would be set, but the chairs wouldn't be. Is that what, you see a conflict?
yeah, I don't think, because if they're gonna be elected chair, I would hope they're qualified to step in and immediately run the meeting. And that would prevent considerable cost and the timing and stuff if we could do it. I don't know what it would do to the staff, but go ahead at 1 o'clock on Monday on the 22nd and just meet early.
Time for,
Or even that morning.
I think so.
it wouldn't be a
I
conflict?
don't think it would be all right.
Okay? That,
Okay, great. Yeah, so 1
so,
o'clock.
special rules Monday, the 22nd at 10 o'clock. Anybody? Y'all have a problem? Timing, you got court or anything?
Now we're doing the 22nd. We're gonna do the 22nd at 10.
You got court, anything like that?
I'm fine. I got a question. What happens if you have vacancies to be filled? You know, let's say Chris gets on, let's say Joe or Bill John. Maybe Joe gets on. What happens?
We have the law reads. I'm the law read on that.
Oh, yeah, Chris won't.
Ms. Coach, did you have your?
Yeah, we have tentatively got community meetings scheduled in Portland and Seattle. The last one will be in Seattle on the 21st and won't end until late in the afternoon. So we will not be able to fly back until Monday morning, and you can't get back here by 1 o'clock
Maybe
from
we
the
should
West
do it
Coast.
on a Friday as originally suggested.
Yeah, that would be a little bit better, I think.
Can we get away?
Yeah, you can get out of here because of the time zones. You can take a late flight out of here and still get there, but you can't get here from there.
Can't get there.
Friday, what's that date on Friday?
It's the 18th. But is it? I mean, I'm gonna broach this subject again after I said I didn't think it would be good. It's the 19th on Friday.
Yeah.
Could we meet right after we're inaugurated on a Sunday?
Jess, oh, you're sitting right there. You just gotta know that.
I don't want to do it on Sunday.
My
family's not gonna do it. If I wrote those down, I might be scratching.
Yeah, that's what we're doing. Go ahead, Sharon, you still have the floor.
Thursday at 10 a.m. just magically worked. Somebody just
What about, does that work on your deal?
18th.
Yeah, because,
As you originally suggested?
yeah, because I could have Wednesday maybe, because see, I didn't know, do you all want new pictures? I have to take pictures of, I have to schedule pictures for like Dick Lay already, and the rest of you want new pictures, or you just want to keep your old ones?
I hope Dick Lay's not already elected.
I mean, not Dick Lay, but, I'm suggesting if I have new ones, I've got to get their pictures
Why
scheduled
don't we
too.
suggest Lee Keener, who's already actually.
I mean, yeah, that's who I was meaning.
Okay.
Lee Keener, I've already got to schedule him for a photo.
Okay.
I would hope we'd all like new pictures.
Well, that's what I'm asking, do you all want new pictures, or do I just schedule the new ones?
Can we do it like when we've all recovered from the election?
That's fine, but like I said, I got to have the whole day, because I know all of you can't come at 10, so I could have her here the whole day.
That we schedule on the 23rd then?
So we'll schedule rules Thursday, July the 18th at what time, Gail? August.
August 18th at 10 a.m.
10 o'clock.
Special rules.
Special rules.
You changed it again?
Yeah.
What day's now?
This is a Thursday.
Gail will send us an email with these dates.
I will make that motion if you need a motion.
Second, for special rules, August 18th. 10 o'clock.
Okay. Everybody okay with that?
Any questions? Please say no. Entertainment motion to adjourn.
So moved.
Second. All in favor, signify by saying aye.
Aye.
We are adjourned.